Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's premier indoor shooting facility. Of course, that is Security Gun Club right here in Woodinville, Washington. Hey, this is going to be a video for my viewers. One, thank you very much, but really directed at those of you who leave comments on every single video that kind of reads somewhere along these lines, which is, why is it so freaking hard? Shall not be infringed. It's pretty simple, okay? And the truth is if I had $1 for every time that one of those comments were left, as you can see here, there would be no reason for me to keep doing YouTube videos. As a matter of fact, if it really were as simple as those 4 words, shall not be infringed, then myself and other people with much larger subscribers than me, who've been doing it much longer than I have, who've been far more successful at this than I have, well, there wouldn't be any need for them as well. So today what we're going to do is we're going to give you kind of some examples so that you can understand that this is a little bit more complicated than you might think. So today, let's spend a few minutes and let's talk about, unfortunately, it is more complicated than just shall not be infringed. Okay, so I know that probably some of my other creator friends out there who do channels of similar natures probably experience this as well, and that is the complete meltdown that we get from many of our viewers when we do a video and they, basically say, what's the big deal? I can't believe I just wasted 10 minutes of my life on this video. Shall not be infringed. It's really that simple. Is it really that simple? Okay, well, what we're going to do here is we're going to give you a bunch of stuff to think about, America. That is, how simple is all of this, all right? And what we're going to do is we're going to actually use real-life examples, that is, examples of successful litigation that preserve the inalienable rights of Americans everywhere, to show you that maybe it's a little bit more complicated than just those 4 words. Let's just start with the big win that we most recently celebrated, the striking down of ATF's bump stock ban in the matter of Cargill v. Garland. Now, here's the thing. You can go back and do a word search on all 19 pages of Justice Thomas's majority opinion, and you will see that the Second Amendment is literally never mentioned in that. Let me say that again. The Second Amendment is literally mentioned. If you think that the bump stock ban was thrown out because it violated the Second Amendment, au contraire, wrong. No, the bump stock ban was thrown out because of simple statutory interpretation going all the way back into the deep history of American law, even into English law, as to how we interpret laws. What the Supreme Court basically said is, listen, you define machine gun as multiple rounds on a single function of the trigger, and you're telling us that the bump stock has multiple rounds for multiple functions of a trigger. Therefore, it's apples to oranges. It doesn't fit. And that is the sole reason by which the bump stock ban was thrown out. And in fact, there is a strong argument to suggest that the court kind of hinted that perhaps a Second Amendment challenge to a bump stock ban might not be as successful. Let's talk about the other big win to come out of the United States Supreme Court this year, NRA v. Vullo. This is where the state of New York, as you know, just went about and basically tried to strong arm all the companies in New York to not do business with the NRA, to drive them into insolvency. Obviously, it was the Second Amendment that swooped in and saved the day for the NRA, right? Wrong. No. This is a First Amendment opinion. It is a First Amendment opinion in which all 9 justices agreed that the state of New York had acted improperly. So that's the Supreme Court cases that we've had so far. We'll get to the ones that are yet to come, but let's talk about some of the other ATF blunders and all of their setbacks. Because see, when we go back and we look over our shoulder and we take a look at all the carnage that's been left behind, you're going to see that maybe the Second Amendment and those 4 words, shall not be infringed, was not the saving grace in most of this. Let's start with the rule on frames and receivers. Or did Congress delegate authority to the ATF for them to regulate chunks of aluminum? Because that's what the ATF thought they could do with that rulemaking order. Now, that rule has been struck down. It has been accepted by the United States Supreme Court in the case of Vanderstock v. Garland. But when the Fifth Circuit struck down the ATF's rule on frames and receivers, they did so because it violated American Second Amendment rights, right? Wrong. As a matter of fact, they never even reached a Second Amendment conclusion on that issue at all. Rather, the rule on frames and receivers was thrown out based upon the Administrative Procedure Act, a piece of legislation which was passed in 1946. Let's talk about the pistol brace rule, or the rule about firearms with attached stabilizing braces, which now also has been completely thrown out in the case of Mock v. Garland. That rule was struck down because it violated individual Second Amendment rights, right? Wrong again. No, the rule was thrown out because of provisions in the Administrative Procedure Act, a piece of legislation that was drafted 1 year after the end of the Second World War. Oh, and then, of course, we have the new rule on what it means to be engaged in the business of an FFL. Translation, all of you are FFLs, which has been enjoined now, not for the entire country, but for large swaths of the United States in the case of Texas versus ATF. And, of course, that rule has been enjoined against all of the named plaintiffs because that rule violates their Second Amendment rights, right? Wrong again. Once again, the saving grace in that litigation is again the Administrative Procedural Act. And by the way, just to see how clairvoyant perhaps some of our legislators were in 1946 when they passed the Administrative Procedure Act, the preamble reads as follows: an act to improve the administration of justice by prescribing fair administrative procedure. Wow, what a novel concept. But I can assure you, and we'll link it up down below in case you want to geek out on it for yourself, the Administrative Procedure Act, yeah, it's a little bit more complicated than just 4 words. And then finally, let's talk about what we still expect from the United States Supreme Court. There's the case of Loper Bright Enterprises versus Raimondo, a case that in all likelihood is going to throw the Chevron deference out into the trash bin of history. Of course, that's going to be struck down because of the Second Amendment, right? Wrong. No. First of all, it doesn't even involve firearms whatsoever. It's a case that's going to be decided based upon Article 1, Article 2, and Article 3 of the United States Constitution. Translation, it's going to be decided based upon how the Founding Fathers intended our country to be established when they first did so. And so what we're going to see here is a huge ruling that is going to have massive effects in the Second Amendment community that has absolutely no causation from the Second Amendment itself. As a matter of fact, the only case that we're going to even talk about today that will be grounded in Second Amendment reasoning is the case of United States v. Rahimi. In that case is going to be about whether or not we as a country have a historical tradition of disarming individuals and what categories those individuals rely upon. But all the other things that you think are going to be up for grabs in Rahimi, like can they actually take a person's right through a civil administrative procedure where the burden of proof is not beyond a reasonable doubt and there's no meaningful opportunity to be heard or cross-examine a witness or any of those things? Yeah, remember, those were all waived by Rahimi at the lower court. So this is going to be a much more narrower decision, yes, rooted in the Second Amendment, but it's going to be rooted in a lot more than just the 4 words of shall not be infringed. It's going to go deep into the history and the development of the Second Amendment. So the bottom line for everyone out there who thinks it really just is as simple as those 4 words right there, understand that in the universe of ways in which your rights can be taken from you, and in the universe in which your rights can actually be preserved, the Second Amendment plays a role, but not nearly as large of a role as you may think. Translation, it really is a lot more complicated than just those 4 words. Listen, we're going to go ahead and link up all the cases that we relied upon in doing this video down below so that you can geek out for yourself on them. If you got ideas for videos that we should be doing here at Washington Gun Law, go ahead and click on that link right there. Some of the best ideas we ever had weren't really our ideas to begin with. If you got any questions about this or anything else related to what's left of our Second Amendment rights, our contact information is down below there in the description box. And then finally, and most importantly, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.